Hello friends, welcome to IS Point. Today is July 28th and we are going to analyze the articles of the Hindu. And before going in for analysis, I request you guys to please review, comment and subscribe my channel. And you can also watch this video in Tamil at UPSC Tamil. And guys, I would like to congratulate those who have cleared the preliminary examination and hard luck for those who couldn't able to get through. See guys, I would like to make one point here. Everyone has their own journey in this examination. So be practical, be consistent, be persistent, don't lose hope. One day you will surely get it. The first article which you are going to see today is what at stake in Hyderabad. So before going into this article, we'll just look at the background first because this article is all about ISDS and RCEP. See, ISDS means Investor State Dispute Settlement. So to tell about this in a crux format, it means any foreign company can sue a nation for its discriminatory policy. I can give you an example. Say for instance, a foreign company is producing a cancer drug and Indian government makes a law that cancer drugs cannot cost more than ₹1,000 and this happens to be an loss incurring factor for the foreign companies. So this foreign company can sue the government for its policy. Fine. So this is ISDS. See, it is an agreement where a company from one signatory state investing in other signatory state can argue the new laws or regulation could negatively affect its expected profit or investment potential and could seek compensation in a binding arbitration tribunal. Fine. So that's it. In a crux format, it means the foreign company can sue a nation for its discriminatory policy. You just remember in this way. And it is a mechanism which is involved in many trade and investment agreements. For instance, if you take TPP, Trans-Pacific Partnership, this ISDS is a mechanism of this TPP. And many bilateral investment treaties between nations include this. And the important factor to be noted in the ISDS is, here the disputes are resolved by an arbitrator rather than the public courts. That is, an arbitrator means is a third person who will mitigate the dispute. See, I have given you the examples of the arbitrator. That is United Nations Center for International Trade Related and Arbitration Law or International Court for the Settlement of Investment Disputes at the World Bank. Fine. So these are the arbitrators who are famous in the present scenario. So they would come in and they would mitigate the problem. Fine. And this system provides only for the foreign companies to sue the state. It is not the other way around. That is, the state cannot sue the foreign companies. Fine. And see, generally what happens is, if at all any clash of interest happens, each party of the disputes appoints an arbitrator. Both of them agree to the third one. Fine. The third one is the World Bank or the United Nations who will be acting as an arbitrator. So it will be binding on the nations sitting there. Fine. See guys, these sort of mechanisms is more suitable for the capitalistic nations where privatization plays a major role than the government. Fine. So these sort of investment state dispute settlement and all does not favor the developing nations like India or socialistic nations like China. So one could imagine how could India sign these sorts of agreements. So that is ISDS. You will have more clarity when we go into the article. And I have also given the members of RCEP and TPP in the diagram format. See, RCEP and TPP happens to be a trade agreement between nations. The RCEP members are ASEAN plus 6 nations. That is, ASEAN nation consists of 10 nations. So ASEAN plus 6 is RCEP. Now TPP consists of 12 nations. Fine. And recently USA has withdrawn from TPP. Now the important point which you need to know with respect to this RCEP and TPP is Japan, New Zealand and Australia are the members who are common to both TPP and RCP. That is, they are members of both RCP and TPP. Fine. See, RCP and TPP are trade agreements between the nations. So it is the group of nations coming together, making their own rules and they trade between themselves. Fine. So these are trade agreement between nations. Now, I told you that ISDS, that is Investor State Dispute Settlement. So this Investor State Dispute Settlement is one of the mechanism which was involved in TPP. Fine. So they have formed their own rules. Now the concern is that because of USA withdrawing from TPP, this ISDS might be imposed in RCEP. Fine. So this is the concern and the article is related to that. So we'll move on to the article now. So coming to the article now, see this article in the first paragraph tries to talk about the leaked test. So it says that the RCEP discussion is centered around these leaked documents. So we need to know what is the meaning of this leaked document. See what happened is last year an US based NGO, that is United States based NGO known as Knowledge Ecology International. Fine. Knowledge Ecology International. They have released a draft IPR chapter which was discussed by India and RCEP. Fine. And this draft IPR chapter which was leaked is famously called as leaked text. So this article talks about that, and one of the important point which to be noted from that leaked text is that the draft IPR mentions many nations are trying to push RCEP towards the standard of TPP. Fine. So coming to the article, so this article also tries to say that as India is negotiating the RCEP, a free trade agreement which look remarkably similar to the TPP, but the factor which happens to be noted from this agreement is that USA has withdrawn from TPP, and it is now the Japan which will play an important major role with respect to the intellectual property rights because of its technological advancement and the patents which the country hold with themselves. So these factors apply and favorable condition for the Japan to allow to make them go for this mechanisms. So this article tries to say that because USA has withdrawn, now it is chance for Japan to look into RCEP with respect to this intellectual property rights, because India and China does not happens to be a member of TPP as we saw before, and Japan being a member of both, it will try to impose its intellectual property regime or rights in RCEP. Fine. So this article tries to say that one of the conditions which have been put forth in TPP and RCEP is that investor state dispute settlement mechanism, and this should include intellectual property as an investment. See guys, intellectual property refers to a creation of mind such as inventions, literary work, design, symbols. So it could be anything. So it is protected by patents, copyright, trademarks. Fine. So it wants to ensure that this intellectual property right is an investment so that they could come under the mechanism of ISDS. Fine. I have explained you what is ISDS is. That is, any private companies can sue a nation against a discriminatory policy. So if intellectual property rights is considered as an investment, then ISDS mechanism could be implemented easily. Fine. So this is what this article tries to say, and this article also tries to say is that India and China could be an favorable destination for these sort of mechanism to be implemented, and India should safeguard against these sort of measures. And this article also tries to bring in that the intellectual property chapter in the RCEP is far more stricter than the WTO TRIPS. See guys, I would like to make one point here. Generally, intellectual property rights are safeguarded by many organizations. For instance, WTO is one sort of example. WTO is safeguarding intellectual property rights through TRIPS, that is trade related intellectual property rights. And one more example could be United Nations WIPO, that is World Intellectual Property Rights Organization. So even United Nations WTO TRIPS is safeguarding intellectual property rights. So this article tries to compare the intellectual property rights of RCEP, which is discussed in the leaked text, and it tries to compare this with the WTO TRIPS, and it says that this intellectual property rights of RCEP is far more stricter than the WTO TRIPS. Fine. And this article also tries to state that even if we adhere to the TRIPS, it happens to be detrimental for the developing nations like India, and it tries to bring in the example of generic medicines. See guys, generic medicines means it is the copy of the branded medicine. For instance, I can give you an example. Say for example, you think that crocin is a cancer treating medicine. Fine. See, this is just an example. So think that this crocin will be bought to the local market and they would make the similar drug with the same ingredients. And the point to be noted here is this generic medicine is the copy of the branded medicine, and they do not come with a brand name but at a lower price. Fine. So they will have the same effect of the branded medicine, but they will not come under a brand name and they will be available locally. So this is called as generic medicine, and this generic medicine is made because of the policies of government, and many developing nations around the world are favoring generic medicines because of their economic criteria and taking population under consideration. Fine. And India is one sort of example. And this article also tries to bring in the example of data exclusivity. See, data exclusivity means any regulating authority excludes the clinical test data of the pharmaceutical organization. See, even I can explain you this with an example. Say for example, an MNC is coming into India and it requires license for marketing. Now, it has to provide this clinical test data, that is what all the ingredients it has in its drug and what all the clinical tests which it has undergone. Fine. Now, data exclusivity means it excludes the presentation of this data to the organization. That is, it does not make make the pharmaceutical organization to present the clinical test data to the regulatory authorities for granting license. Fine. So this is called as data exclusivity. Now, this data exclusivity also prevents generic medicine making, because see, this clinical trial test could be utilized for making generic medicines. Fine. So this data exclusivity protects them. So this article tries to say that this data exclusivity and this patent term with respect to the generic medicine is a detrimental factor for the developing nation, and including intellectual property as an investment under ISDS is a detrimental factor, because including IP would include all of these factors, that is patent with respect to the drugs and data exclusivity. Fine. And it also tries to bring in the effect. The effect which the article tries to mention is that it would delay in the entry of genetic variation of medicine, plus it would extend the patent monopoly, and exclusivity of drug could bring up the cost of the medicine. And it tries to say that the scenario for this is because of the pharmaceutical company blooming up in Japan. It says that many MNCs are growing in Japan or lobbying in Japan, and especially on the pharmaceutical side, and they are pressing hard to bring in strict IP rules so that it could benefit them. And it tries to bring in an example of a drug manufacturer, Otsuka. See guys, I have given you the spelling here. So it tries to bring in the example of this drugs maker who makes drugs for tuberculosis. And it also tries to say that if this intellectual property rights is implemented, then it would affect especially the tuberculosis patient in India, because it would increase the price of the drugs and there would be no cheaper generic alternative. Fine. So the crux of the article is that because of intellectual property rights, generic medicine and data exclusivity will be implemented, and because of this, the prices of the drug will grow up, which will impact Indian patients. Fine. And this article also tries to bring in the clause of most favored nation. See, most favored nation is a clause of WTO. To tell in a layman language, most favored nation means every nation should be treated on equivalence. For instance, I can give you an example. If India signs the ISDS, that is Investor State Dispute Settlement with Japan, then India cannot deny the same with respect to USA. Fine, it has to accept it. That is, it cannot show favorism to one nation at the cost of other. Fine. So this is what is called as most favored nation. That is, every nation should be treated equally. So what the article tries to say is, if India signs RCEP with respect to the intellectual property rights, then it expands the standard of intellectual property rights, making it more stricter. Fine. So every nation would come into play for a sign under this clause. So what the article tries to say as a conclusion is that the 19th RCEP summit, which is going to be held in Hyderabad, could be used as a platform to resist the pressure of Japan with respect to the intellectual property rights, and India should make sure that it bring in all the developing nations for an balanced intellectual property protection, and it should also encourage countries and should bring in measures to ensure generic competition. So that's it with respect to this article, guys. If you have any doubts with respect to this article, please mention in the comment box. I can explain you better. So we'll move on to the next article now. And coming to the next article, see, the next article is all about whether we should go for privatizing the hospitals, that is district hospitals, or whether it should be under the government purview. See, before going into this article, we'll just look at the background first. Recently, what happened is Niti Aayog and Union Ministry for the Health and Family Welfare have proposed a model contract for privatizing the district hospitals. See, it is not fully privatization, but what they have suggested is a part of the district hospital will be leased to the private players, where they would set up their infrastructures, and even the district hospital would provide them back-end infrastructure services like blood banks and ambulance services. And see, this is a sort of cooperation with the private players, right? And even they made the suggestion that the state government can also provide funds for the private players to set up new hospitals, and they could refer few cases related to non-communicable diseases, screening centers, and they could also implement government health programs where the private hospitals could be made ventures. And they have also made an eligibility criteria. The eligibility criteria is that the district hospital should have at least 2 years record of treating more than 1,000 cases per day. So this is the eligibility criteria for the district hospital to go for privatization. See guys, this is just a suggestion and it is presented to the states. So here comes the argument with respect. So coming to the article now, public health and private players. See, in this article, 3 different views is present. First, the leftists argue that the privatization player will cherry pick their lucrative district. That is, they will choose only those districts which are profitable to them. And this article also tries to criticize that there is a escrow account which is present here. See, escrow account happens to be a temporary account. I'll give you an example. For instance, you want to buy a home, but the real estate builder has not completed the project. Fine. So, in order to create a confidence, what the real estate builder will tell you is, you create a temporary account. After the project is completed, I will get the money from this account. So your money is also safe because it is in the temporary account, and at the same time the real estate builder gets the confidence that you will buy the project of him. So this is called as escrow account. It is a temporary account which is created, fine, in order to build in a confidence. So there is an escrow account which is present to the private players from the government. So this article tries to say is that this escrow account does not bring in accountability because they will get the money only when the project is completed, and this does not allow them to complete the work at time. Fine. See, one can argue it this way, and the other one can also argue this way that in order to get the money, they would implement their work faster. Fine. So even both way argues there, but the left argue that escrow account is detrimental. Fine. And even the leftists argue that bringing in privatization in public hospital would means that one has to pay even in the public facilities, which is a worrisome factor. And even it tries to say that it will bring in inequality because those who pay more will get the healthcare services, and it will bring in unethical practices. It will comprise equality and rationality of services because the money will peak a lot, and it is unsustainable over a long period of time because see, the government objective is welfare of the people, and bringing in privatization would ensure profit making. So this is not an justifiable move, and the remedy which the article tries to give for this is one should go for the training of health workers, and ideological moorings should be there. See, ideological moorings means the government itself thinks that the public healthcare hospital is not up to the mark, so they have to go for the privatization. So this in itself is a negative factor for the government projects. And this article also tries to say that health is a state subject, so the state government should ask for its legitimacy to be implemented. Fine. Now the right argue for the privatization. They say that national health policy has been implemented recently, and the national health policy advocate for strengthening the public health system, and the government infrastructure is a little less. There is need for a higher investment in that. So bringing in privatization could decrease them, and non-communicable diseases requires expert, which is well played by the privatization sector, and there is no existence of treatment in the tier 2 and 3 cities right now because even the private players are not present in tier 2 and tier cities. They are concentrated only at the major cities. So bringing in privatization in the district hospital is a welcome move, and this could also avoid overcrowding in the private hospitals to an extent. And this article also tries to say that they cannot remain oblivious to the present need. That is, see, the present need is that one needs to ensure primary, secondary and tertiary services to the people, but the government cannot postpone this target to a greater extent. Things needed to be implemented in a fast manner, and there is a gap which is present now. So to fulfill this gap, this action has been taken. And they also tries to say that even though privatization comes into play, it will ensure free services to the BPL family, and they also tries to say that bringing in privatization could not be successful is too early to speculate. That is, one cannot judge. However, in the existing environment, there is a need for such sort of partnership. So this is what the right argue. And the center argue that district hospital needs upgradation. Non-communicable diseases are also affecting more people in India. So there is a need for privatization to fill in the present gap. And the center tries to ask some interesting question. See, it tries to ask whether private investment is required to strengthen the district hospital. That is, why can't the financial support is provided to the district hospital directly, and why there is a need for the privatization to be bought in for enhancing the district hospital. Fine. Why can't the fund be directly given to the district hospital to upgrade itself? And why private sector be directed to create the public sector capacity? So these sort of questions the center tries to place in, which is quite an interesting question. And the center tries to argue that there is a need for universal health coverage that indicates primary, secondary and tertiary services, but bringing in privatization could improve access and could improve quality, but at the same time it will not deliver approximate and equitable care. That is, it could not bring in equality and the required target which the government seeks. Fine. So this is what the center argue. So that's it for today, guys. And guys, I would like to make one important point. It is not important actually. Like yesterday and day before yesterday, I did not upload my Hindu editorial videos because of my health issue. I apologize for that, for not being consistent. And I also assure you that from today, I will be regular and try to maintain the consistency. Because see guys, it is me alone who is making this video. So it takes a lot of time for me to bring up the videos. So I hope you guys could understand. And guys, one more thing. If you want me to make videos on other subjects, yes, I am ready to make videos on other subjects too. Please give your opinion about it so that I could make some awesome videos which could benefit you. And it could be in relation to anything. It could be in relation to guidance. It can be in relations to any subjects, or it could be in relations to any specific thing. So please comment so that I could make some videos which could benefit you. Fine. So that's it for today, guys. Thank you. Thank you for watching.